Welcome to Heartbreak and Hope with Pat Barbarito, the show that explores how to build up or break down any relationship with confidence, clarity, and compassion.
When we talk about family, we often conjure up visions of a mother, a father, children. Well, sometimes we think about grandparents and aunts and uncles. In fact, when you look up the definition in the dictionary of a family, it's a, quote, social group made up of parents and their children, a group of people coming from the same ancestor. These traditional notions of a family, of course, they come from our own experiences, what we've been exposed to, and what we've seen in the media. According to the U.S. Census Bureau, children living with two parents has historically been the nation's most common children's living arrangement. In 1968, there were about 60 million or 85% of U.S. children under 18 that lived with two parents. But by 2020, that number dropped significantly. Although children living with both parents is still the most common living arrangement, the number of children living with two parents in 2020 slipped to 51 million or about 70%. Today on Heartbreak and Hope, we're going to talk about what is family. We're going to talk about the ties that bind and make us a family. We're going to discuss the traditional notions of family and how we're expanding that concept through the law and through just living. Today with us is Matheu Nunn. Mathew's one of my law partners, but separate and apart from that, he's an experienced litigator. He's tried jury and bench trials. He's been counsel in more than 60 appellate division and New Jersey Supreme Court matters, including precedent-setting family law decisions. What distinguishes Matt's work is his representations of family that may be perceived as non-traditional and his urging of the court to recognize these different types of families as families under our law. It's often heartbreaking to be a member of a family that is not a traditional family. It's often heartbreaking for a kid in school to have perhaps two moms, live with a grandparent, be a foster child. But we're here to talk about the hope that comes from creating a family that's not recognized in our dictionary. So Matt, welcome, first of all.
Thank you for having me.
Before we talk about the law and your experience and your desire to push the courts to recognize non-traditional families, I sort of hate that expression, but I think it captures it. You and I, as partners, talk a lot about this because of our own respective situations. So if you would talk to our audience a little bit about your situation that makes you pretty sensitive to this topic.
I'm not married, but I'm engaged. I don't have my own children, but I'm engaged to someone that has 3 children. That is certainly a new experience for me. But in the future, hopefully the near future, I'll be one of these categories of people, a step parent. One of these categories of non-traditional, non-biological or non-adoptive parent who's now, in a child's life in a different way. There are categories of people, grandparents, aunts, step-parents, siblings, et cetera, et cetera. These categories of people, depending on what state you're in, but many of the states are similar, they may be entitled to visitation rights.
All right, so before we get there, and I want to talk about that because it's fascinating to me. In your situation, though, you, your fiance, and the children, you sort of look like, postcard family, right? Yeah. So that helps a little bit. In many of these situations where you have grandparents or younger people or foster children or children from different backgrounds, I think the heartbreak is in that presenting that to the world takes a while for the world to recognize them as a family. Where does this notion, this idea of a traditional family come from in the law? It baffles me, it confuses me, and it makes me a little angry sometimes.
A variety of sources, right? Think the IRS code that used to be only certain people could file and claim a child as a dependent, right?
Is that still the situation?
No. But it used to be, gay marriage wasn't legal. You could have two people who aren't married, who weren't recognized by the federal government for tax purposes as being a family unit. Now clearly that has changed for the better.
Well, only recently.
Surprisingly, only recently, but it has changed. But really, at its core, and this will be important to everything else we talk about today, at its core, The notion of a family and the rights that come along with being a family or a member of a family and a child comes from our Constitution.
What do you mean from our Constitution?
Yeah. So
I thought I knew a lot about our Constitution. I would never think that family is derived from our Constitution.
we all know the language, life and liberty, right? You're entitled to that under the Constitution, right? And
Sure.
you can't be deprived of it, right, without due process. Think about it. What right does a judge or the government or anyone have to intrude into Pat Barbarito's family, right? The Constitution makes you free of that, right?
Yes.
Okay.
Liberty.
Correct. And so within the fundamental right of liberty is the right to be free of intrusion of government. But there are times when there are exceptions to that. There are multiple amendments to the Constitution. Many of us know what they are, right? The First Amendment, speech, Fourth Amendment, search and seizure, et cetera, et cetera. But ultimately, when the government makes decisions about children and families and what those things are going to look like in the future, they are exercising a right that exists within the Constitution. And then a fundamental right can be impacted under a court's obligation as parens patriae. And Pat, you know what that is. Your listeners may not. Parens patriae basically means, in lay terms, the government has a right to act on behalf of its citizens in their best interest, or really to protect them. These notions of a traditional or non-traditional family, non-traditional families only truly exist and are recognized under the law, okay, where there's a conflict between people, grandparents, grandchildren, aunts, uncles, and kids, step parents, etc. Those things can only occur in court. A judge can only act under its parens patriae obligation to protect children, to protect its citizens, and children are citizens.
In that regard, I know our U.S. Supreme Court and New Jersey Supreme Court have recognized the concept of psychological harm.
Yes.
And I'm curious, Matt, in that recognition, are you telling our listeners that the courts could reconfigure a family from mom and dad and child to child and caretaker?
Unequivocally, yes.
How is it possible that you have a child, that child is your child, and the court could come in and redefine the definition of family?
So, like any right that we have, right, the freedom of speech, right, it can be tempered, it can be infringed on, it can be limited. The right to not have your home searched under the Fourth Amendment, that can be limited, that can be infringed on under certain exceptions. The same thing applies to a family. Although there are many cases, and we don't need to discuss too many of them, the one that gets cited most often, Pat, when we talk about these things, from a U.S. Supreme Court perspective, is a case called Santosky versus Kramer. I'm not even going to talk about the case other than to tell you it involved New York Child Protective Services and that they wanted to remove a child and terminate parental rights of these parents. But what's important, what came out of that decision, is the notion that to do that, you need to give parents due process, meaning you can infringe upon their rights if there's due process. Well, what does that mean? They're entitled to a hearing. They're entitled to present their case in court. But ultimately, and Pat, this now, what I'm about to say, bleeds down into all 50 states, this principle. Parents have a constitutionally protected fundamental liberty interest in raising their biological children, even when the children are temporarily placed with someone else, which could include foster care or a grandparent or someone else. So that's sort of the fundamental baseline of everything we're talking about today.
But if the children are going to be removed from the parents and that fundamental right is taken away, are those parents, is that parent entitled to due process, a vetted, thorough hearing? And how about the parent who can't afford that?
We all know, you watch Law and Order, you hear this. Beyond a reasonable doubt. That's the standard in criminal cases. Santosky, the state of Washington, had a preponderance of evidence standard to allow these people's parental rights to be terminated. And the Supreme Court of the United States said, no, you need to have a higher standard, a higher burden.
What does that mean?
It could mean 51%, 49%.
But you have to have a hearing. So you have to have a hearing to convince a court by a preponderance of the evidence that this child should not be with the parents, that the right should be terminated.
So in Santosky, which is a 40-year-old case now, they said that standard is too low. It needs to be clear and convincing evidence. It's a higher burden. It's not quite the criminal beyond a reasonable doubt, but basically The government, in a case where they want to remove your children, can come in and do so after a hearing with discovery, where people have a right to flesh out what the state is going to say. The standard's clear and convincing. But many of the cases that we see, including grandparent cases, including grandparent visitation cases or grandparent guardian cases, many of them originate from a child protective services becoming involved in a biological parent's life.
Are you telling our audience that the court could come in and remove a child and terminate the rights of a parent and make them no longer parents and reconfigure a family?
Yes and no. So let's start with this. It's not the court that does it. It's the government. It's the state of New Jersey, the Office of the Attorney General, Child Protective Services, DCPP, whatever state you're in, whatever they have to protect children. In most cases, Pat, let's say you have a child who isn't being fed enough, or comes to school in dirty clothes, or isn't being bathed. Something short of sexual abuse of a child or severe physical abuse of a child. The first step of Child Protective Services is to provide services to the family to keep the family together. So the goal is initially to keep the family together. As you can imagine, many people do not avail themselves of those services. And eventually, and this maybe is a nice segue into some other more happy subjects, eventually the court and the state will get to the point where they say, okay, we've given this person 12 months or 18 months of services, drug treatment, counseling. We've given them financial services to make sure that they have food in their cupboards. If a parent continues to not meet those obligations, eventually the state and the court can move towards termination as opposed to reunification and services.
But that sounds like it would cost a lot of money, Matt. So how does somebody who's clearly struggling enough that the court is looking to terminate their parental rights, how do they afford that?
If they're a certain level below the poverty threshold, they're given free counsel. And the child is also given a free independent attorney. I say independent, they're all appointed by the state, but it's not team state of New Jersey versus mom or dad. The child has his or her own attorney, and they're provided by the state. Unfortunately, it's one of those situations where, sort of like applying to college, right? If you're middle class or upper middle class, you might have just enough money that you don't get enough financial aid to go to college, but you make too much to get the free attorney from the state of New Jersey. Yeah, I mean, look, there's a quandary for people who are sort of middle class, who have DCPP involved in their lives. They're not going to get a free attorney appointed for them. The flip side is they need an attorney because these cases can cause significant tumult in their lives.
So I know you've been involved in these cases, and my experience is that it is not a casual application that's made to remove children from their parents. In fact, it's a carefully scrutinized one. But in the cases that you've been involved in, it sounds so heartbreaking because the vulnerability that you must feel and the stress you must be under to not care for your children properly is extraordinary. So can you share with the audience perhaps some of the heartbreaking situations you've experienced when in fact termination is inevitable in order for the child to thrive?
Yeah, look, I mean, they sort of run the gamut. You have people who have mental health issues, who quite literally can't help it, cannot even theoretically raise a child.
Yeah.
The state does their best, I think, to assist those people, but there just comes a point where, remember, there's another person in this equation. There's a child, and the child has a right to have a family and to be raised and to be healthy and to live a good life.
But the child only knows the parent, even if that parent is limited. And that's heartbreaking.
It is. But eventually, as you know, the longer a child goes without stability or permanency, it impacts them for the rest of their life. They can develop personality disorders. Listen, I've been involved in cases where, and I mean it, and was borne out in court after a trial after discovery. One person, and I don't say this flippantly, had multiple children and obtained welfare for each of the children, and basically would move from state to state when their resources run out. And I'm being dead serious. This is not me, casting aspersions. That was this person's intended goal, to sort of milk the system.
Were the children taken away?
Two of the children were taken away. One of the children was adopted by my client. One, the state of New York had come in and taken away one of the children and placed it with the biological father. And while my case was pending, this woman had another child. DCPP gave that person every opportunity. The court gave her 3 trials. She didn't even bother to show up for one of the trials at all. The person was capable. The person was receiving government assistance. She just chose to absent herself from it. But I would say in most cases, you're dealing with someone who has mental health issues and or substance abuse issues.
You've been involved in those cases. Isn't it hard to watch somebody who really wants to do the right thing that just can't, and they have to have their rights terminated? I mean, I know people think of lawyers as advocates. We are advocates. People sometimes think of lawyers as heartless. But the truth is, I've seen you involved in some of these cases, and really sad that you have to be the one who's involved in the termination hearing. I mean, I've seen you suffer over that.
Yeah, I mean, you're ending someone's right forever and all time to be a parent of a child. Look, I have a job to do, and I don't feel as sad, Pat, because if you think about it, children are resilient, and when they spend enough time with someone and they no longer see their parent because maybe they have a drug problem and they just can't kick it, children start to see other people as their parental figures in a positive way. So, as much as I look at it as, you can only adopt once you terminate someone's parental rights.
Right.
The adoptive parents, right? That's a conditioned precedent to adoption. The child is gaining parents, right? And so, yeah, I guess sometimes theoretically, and in some instances, yeah, I have felt badly about having to do it. But the flip side of that is, and again, one of the cases we'll talk about today, I remember at the adoption hearing crying, bawling, because the case went on for 7 years. And at the end of it, now this little girl was with her family, who she had already perceived to be her family the entire 7 years the court case was going on. But now it was official and it was over with. And she cried because she knew it was over with.
The hopeful part of this conversation is, and I've sort of always believed, particularly as a parent of non-biological children, that family is destiny. And I always say, to my daughters, we were destined to be a family. But when it doesn't happen in the traditional sense, there's a lot of emotions that run through the children and the parents. So it's difficult, but there are such hopeful situations at the end. Let's talk about who else besides biological mom and or dad has the right to be a parent to a child. Anybody? Everybody?
Other people other than the state of New Jersey or the federal government can intrude into a family. Now, your listeners may be saying, whoa, wait a second, what?
So let's put DCPP, DIFUS, state agencies, throw them out. They're not coming in and saying, we want the biological parents terminated. Throw them out.
Correct.
Who could come in?
There are other, quote, exceptional circumstances, end quote, that allow a court to give some other third party, I don't want to say necessarily parental rights, although we'll talk about it, in some instances they can, but certainly intrude into a family and have visitation rights at a minimum. In New Jersey, and frankly, I believe all 50 states, the last time I checked, there is some form of a grandparent visitation statute. I emphasize the word visitation, because visitation does not mean you then get to dictate where your grandchild goes to college, who their friends are, what they do on Saturday night, what kind of car they get, are they punished if they get bad grades? Visitation, you have no right to any of those things. You just have a right to visit.
So as a grandparent or sibling, you can get the court to order a right to visit, even if the biological parents don't want you to.
Correct. Now, from the 60s until the late 80s and even the early 90s, states across the country started adopting these grandparent visitation statutes.
Yeah.
And the way most of them were drafted, they almost read like and were being applied like a custody statute. Like, is it in the best interests of a child to have visitation with their grandparent? So think about that. If parents have a fundamental right to parent and a grandparent doesn't because they're not the biological parent or an adoptive parent, why are you applying the same standard to a grandparent's visitation with a child? So eventually in 2000, the United States Supreme Court gets involved and says, wait a second. The only people who have a fundamental right and are on equal footing with each other are parents. So if a grandparent wants to intrude in someone's life, or an aunt or an uncle or a sibling, the standard needs to be something different. In New Jersey and frankly every state, for a grandparent to obtain visitation, the first thing that they need to establish is that in the absence of visitation, the child will suffer harm. And I don't mean physical harm, I mean emotional or psychological harm. So basically, the parent, the grandparent or a sibling or someone else has to prove a negative.
I know of a family who I'm very fond of, who their 39-year-old daughter tragically died suddenly. And the father of these children moved out of state and has put up unbelievable roadblocks to these wonderful people seeing these children. And it's not a slam dunk. They have gone through hell and back. Not only did they experience the heartbreak of their daughter suddenly dying, but their two granddaughters have not been accessible to them. How is that possible? How is that not in those children's best interest? It makes me furious.
Remember, the grandparents are not on the same footing as a biological parent under the
So
law.
there's one biological parent left.
Yep. And that person has a presumption of having a higher right to make decisions on behalf of their children. Okay.
And they can make a decision that
Yes.
your mother, who passed away suddenly and tragically, her parents who were very involved with you, shouldn't see you.
Yes. Now, you can go to court and petition the court as a grandparent and say, it's harmful to these grandchildren. They had lost their parent. They're now losing a relationship with us by severing, in your case, this example you've given, the maternal side of the family. You're breaking a bond that already exists. You're going to cause them psychological harm in the future, if not now. That's the standard. And if a grandparent can say at a threshold level, if they can prove that some level of harm will befall a child by being separated from them or sort of cut off from them, the court is then obligated in New Jersey, for example, to say, okay, I agree with you, grandparents. If little Johnny is no longer allowed to have you in their life and their mom passed away and now they're going to have no connection to that entire half of the family, I agree with you. You've met your burden. I now need to come up with a schedule for this visitation. But make no mistake, the grandparents under that scenario, they do not have any parental rights. They just have a right to visitation. And so the surviving biological parent can still create roadblocks, or they can create parameters by which they'll allow visitation. You know, the cases are difficult. They're not easy to prove. But just so your listeners know, the statute in New Jersey is not limited to the surviving parents of a child who's the center of a dispute.
So you could have mom, dad, children. Mom's estranged from her parents. Her parents could come in and try to override mom's decision, and they could get a separate schedule, you're telling us.
Yes, it is very difficult where both surviving biological parents are opposing a grandparent's application for visitation. Those cases are very difficult to succeed upon on behalf of the grandparent or grandparents. They're almost impossible.
So let's talk about the situation where somebody beside the biological parent wants to step in and be the parent, be the family, so to speak. How does that happen? In my situation, my oldest daughter being a biological family member, there were a lot of twists and turns, and I ultimately adopted her, but it wasn't easy. Who could come in and say, you're no longer mom and dad, I'm your parental figure? Who has the right to do that? Does it have to be a biological relative? Could it be a third party? Could it be a step parent? How does that work?
It could be any of those people. I get the question becomes, who could successfully come in?
Better question.
Do that, right? So Joe Blow off the street could come in and say, hey, I want to be the parent of this child. They're going to get laughed at court if they don't have a relationship. So the focus then truly becomes on, is there this sort of psychological parental relationship? What does that mean?
What does that mean?
From the child's perspective, does the child have in lay terms, such a strong connection with that person, that third party, that non-biological parent, that they're in sort of a de facto parental role? You know, this theoretical person we're talking about, it could be anyone, like a grandparent, an aunt or uncle. It could be, you know, a daily caretaker. Hey, Pat, here's an example I give people when they come in for consultations. I had a grandparent who lived across the street from me. Okay. Now, by the way, I'm in one of these families where my dad and mom, they literally live in my dad's childhood home. So my dad is 72. For all but like 1 year of his life, he has lived in the same house.
Gotta love them.
His brother lives next door. His other brother lives across the street, like down the road, and the other one lives in like 2 towns over. So at some point in time, my grandmother moves across the street from us, and I saw her every day. Whether she was at my house or I was at her house, or I was running back and forth and she's cooking us dinner and my parents are working, you know, one of those situations. If my parents tried to cut her out of my life, that grandmother would have been able to go to court and pretty much get whatever she wanted with me, right? She saw me as much as my parents did, quite frankly. My other grandmother, who I did see a lot when she lived in the area, at some point sells her house up here and does what most people do. They move to Florida. So I would only see her on major holidays, a phone call. Hey, grandma, I love you. Goodbye. Okay. One of those things. I was a kid. I didn't really want to be on the phone with my grandmother. If that grandmother tried to get some sort of court ordered visitation or something with me, she would fail. And, it stinks that my parents would be able to do that because my grandmother loved me and she wanted to talk to me and see me. But you can see based on those two examples, the difference. The type of
psychological bond. There's a relationship.
Yeah.
You first have to have a termination in order to become a parent, correct?
So yes and no.
Okay.
If a child is to be adopted by someone else, the biological parent's rights need to be terminated. The legal relationship between parent and child needs to be severed before someone else can step in and be someone's legal parent. And by the way, it happens with adults. You can have adult adoptions. However, there's another category of people who have a psychological parent relationship that are allowed to remain involved in a child's life, even if the other biological parents are alive and even if they object to it. And that's based on the psychological harm relationship, meaning let's take husband and let's say the children that came into this marriage, okay, they perceive these people as their parents, okay? They don't have relationships with their biological parents from the prior relationship. Now, let's say they get divorced. They come see Pat and they get a divorce. And let's say Pat's client says, well, listen, I don't want this guy having access to my children, that person's stepchildren. The other party may say, well, wait a second. For the last 13 years of my life, those have been my children. I've paid, I've contributed to their college funds. They perceive me as their father or mother. And I believe it would cause substantial harm to those children if you completely cut me out of their lives. So in that circumstance, even though the step parent didn't adopt those children, right, the other parental figure still existed, that person could seek an order for visitation and to be a parental figure in that child's life based upon the notion of being a psychological parent. You could imagine the difficulty in proving one of those cases.
Well, you could, but if somebody's living with somebody for 13 years, going to their ball games, their back to school meetings, very involved in their life, I think it's obvious there's a psychological bond. And I can't imagine it would be in the child's best interest to cut that person out. Matt, as you're speaking, I'm thinking to myself, at what point does the right to parent a child, either through adoption or psychologically, trigger a financial obligation to contribute? Because that's that fine line. It's one thing to say, I'm your psychological parent, I care for you the same as a parent, but at what point does somebody have to sort of put their money where their mouth is and financially contribute to that child? Does that happen before there's a legal recognition of the parent?
It can happen. So there's a direct answer, which is if you adopt a child, you as a matter of law are now that person's parent. You assume financial responsibility.
Absolutely.
A divorced step parent who has some level of visitation doesn't have an automatic obligation to pay child support. Doesn't seem fair, but there could be an application made by the biological parent to compel the person to pay some level of child support.
That would be an uphill battle.
Look, if you want to be involved in someone's life, you got to take the good with the bad. And sometimes the bad might mean a financial obligation. But I want to reiterate to people that listen to your show that it is very difficult for both the state of New Jersey and any of these third parties we're talking about to develop and create an obligation of parenting based on psychological parent. It is a heavy burden. It often requires expert involvements of psychologists and psychiatrists. In most cases, you're talking six-figure litigation costs. But the flip side of that is if you believe in the cause and you believe that it truly is in a child's best interest and it will cause them harm if they don't have a relationship with you, listen, Pat, we've had clients who say, I don't care what it costs. I think that it's in my grandchild's best interest to have a relationship with me. I'll spend every last penny I have on it. but they are very difficult. And I say that for two reasons, Pat. One, I don't want people to think, oh my God, these people are going to come in and I better cut my parents off now or else they're going to be coming in to get,
Yeah.
or, I better not let my sister-in-law keeps coming over and wanting to see my kids. Like I got to keep her away. The level of relationship that must exist to intrude on either adoptive or biological or, however it is you get into a parental role, to intrude on that is a very heavy burden. It's very difficult.
Other than termination applications or visitation right applications, are there other mechanisms that people, family members or non-family members, can use to have a say in the child's life, like legal guardianship, kinship guardianship, so that they have a parental role, but they are not a legal parent?
Yeah, so kinship legal guardianship usually comes up through DCPP cases where DCPP or Child Protective Services, whatever you want to call it, has removed the child. And it's very clear to everyone involved that the parent whose rights have now been intruded upon at no point in the near future is going to be in a position to parent. So kinship legal guardian, would allow a grandparent or a sibling or an aunt or an uncle to become the legal guardians on behalf of the child, but not have the biological parent's right terminated and the child adopted. But I would say in a significant number of those cases, Pat, there comes a point where the kinship legal guardian says, well, listen, I've been taking care of my grandchild for 8 years. My son-in-law or my daughter or my son, whatever it is, whatever the other person is, they've done nothing to improve their situation in life. They just like the fact that I'm here, I'm paying for things, I'm doing everything, I'm responsible for
And
homework.
they get to be mom and dad.
And they get to be mom.
Not fair.
So in a lot of those cases, the kinship legal guardian will attempt to then adopt the child. And I have to tell you, if the kinship legal guardian or a legal guardian, whatever, you start being responsible for a child for 4, 5, 6, 7 years, and the biological parent has checked out and occasionally sends little Johnny a card or something, you run the risk as the biological parent that the child could be adopted over your objection.
You run the risk as a legal guardian that
Correct.
the child could go back to the biological parent.
You also do run that risk.
It is as a parent who raised my oldest daughter without definition for a number of years, it was scary to me that was even a small possibility because it just doesn't seem fair. But we have to stay focused on what is in this child's best interests.
Yeah, and listen, in most of the cases, whether it's a case I've been involved with or a case that's been decided previously that we as lawyers read about, I think where courts have the biggest problem is where a biological parent's rights are sort of trampled over or they get steamrolled.
I mean, that's not that common because the biological parent's right to due process is pretty paramount. So, I mean, that seems less likely.
Pat, it does happen. And again, remember, in many of these cases, you're dealing with a biological parent who may have a 5th grade education, may be addicted to substances, may make poor decisions, may voluntarily, because they don't understand what they're doing, give their kid away.
So when we were talking about this topic and doing this episode, there's no more topic that is as obviously filled with heartbreak and hope all in the same situation. Somebody's going to be heartbroken and somebody's going to be hopeful, a parent or a child. And I'm wondering if you could share with our audience some cases that you've been involved with that really exemplify that.
The first one that comes to mind is an adoption case that Pat, our partner, Mark Wexler, who has since passed away, brought into the office. Mark didn't know the first thing about adoption law and came to us in 2013 as an appeal. I'll do my best to keep the facts short, but I'll give you the salient ones. So 2-year-old girl's growing up with her mom. Dad's not around. Mom is in shelters, in and out of shelters. She gets kicked out of shelters because she doesn't comply with the rules of the shelter. The kid is underweight. At 2.5, can't walk, has no motor skills, has, still doing gaga goo goo like a baby. If I'm going to give any credit to biological mom in the story, I'll give this credit. She realizes, I think at this point, like, I can't parent a child at this point. Now, mind you, she had other children, one of whom had been taken away from her, but she places her child with an adoption agency in 2012. What didn't happen, and this sets the tone for the next 7 years of litigation.
While the child was with the family.
Correct. What didn't happen is the biological mother never actually signed a surrender of her parental rights.
Was that just a technicality?
It is a technicality, but an important one. what she did is she signed a form that said, I'm placing my child for the purposes of adoption. But again, she never actually knowingly signed a surrender of parental rights waiver. So this child gets placed with these people who end up being my clients. But initially, they weren't my clients. They hired some other attorney who filed a petition for adoption. And they have a 2-day trial in Essex County in 2013. And at the end of that 2-day trial, the biological mother who participated in that trial and who was not represented by counsel, her rights are terminated. And she files an appeal. And, appeals take some time to resolve. This was the beginning of a near 7 year. It was definitely 7 years from the initial placement, but, my involvement was close to 7 years. My clients are the foster parents. I'm going to use this word, this sounds terrible. They're in possession of the child. They're taking care of the child. They're paying for things for the child. They're getting the services the child needs. Her speech improves, her motor skills improve. She walks, right? Her life's going much better.
And they're bonded.
Without question. And the foster parents had another child who now this child is perceiving as her sibling. Now we're in 2013 and, the trial happens. The rights are terminated. The biological mother appeals the case to the appellate division. And in a published decision, which means precedent setting, it's binding on all future courts and attorneys and litigants, the appellate division of New Jersey undoes the adoption. They vacate the adoption and they say biological mom should have had counsel appointed for her. Now, at the beginning of this conversation, I told you indigent people, when the state of New Jersey is involved with them, get attorneys appointed to them. Well, unfortunately for my clients and unfortunately for me, there was a hole in the law. And the hole was my clients were pursuing the termination of rights and adoption, not the state of New Jersey. And so the biological mother didn't have a right under the law at that point in time to have counsel appointed.
But the appellate division saw it differently.
The appellate division said, yeah, we understand that this kid has been with your clients and they're bonded and all that great stuff, Mr. Nunn. But we're gonna do a do-over.
Go back to the beginning.
Go back to the beginning, have a new trial because she needs to have counsel appointed for her. And in addition, Nunn, we don't like how this all played out. We're ordering the immediate resumption of visitation between the child and her biological mother.
Which must have been extraordinarily confusing to this child.
So when something like this happens, I'm like a dog with a bone. I knew it wasn't right, meaning I accepted and could understand as a matter of constitutional law that an indigent person whose parental rights are going to be terminated should have counsel. But the fact that after years of not seeing her mother anymore, her biological mother, and perceiving my clients as her family and siblings and mom and dad, we're now just going to thrust her back into a relationship with someone who really, quite frankly, didn't really do much for her while she did have her. So within like a day of getting this appellate division decision, I go to the Supreme Court of New Jersey. I file a motion. I ask them to take the case, and I ask them to stop the visitation. By this point, we're in 2015. By the time we get the appellate division decision and they order visitation, we're in 2015. The Supreme Court agrees to take the case just before January of 16, but they also do something else. They now send the case back for a mini trial. So remember what I said, the appellate division sent the case back to redo the adoption. The Supreme Court has now taken the case. They're going to review everything, but they send the case back to the trial court, Judge Katz in Essex County, and they send it back for the limited issue of if we order a resumption of visitation with biological mom, is that going to cause the child harm? So think about this. I've now flipped the entire thing on its head. And now is biological mom going to cause harm by being with the child? I spent, Christmas into the beginning of New Year's of 2016 preparing for this trial. We had a little 4-day trial before Judge Katz. At the conclusion of that trial, he says, look, it seems pretty clear that if I now force this child after not being with her mother for 2.5 years and not seeing her or not perceiving her as her mom, it's going to cause harm. So the Supreme Court takes the case. Visitation doesn't happen. But about a year later, I lose again at the Supreme Court. And the Supreme Court says, we agree with the appellate division. There should be a constitutional right for an indigent parent in a private adoption case to have counsel.
You have to go back to the beginning again?
I go back to the beginning. But while this is going on, I was able to get the Supreme Court to stay the visitation.
In other words, put the visitation off until this thing was concluded.
So effectively, for 3.5 years, this child who was with my client, she was bonding and attaching with her foster parents or her adoptive parents and her adoptive sister. And now she's fully immersed in their family. Like that's her family. She doesn't even know who her biological mother is. Unfortunately, though, we now had to have another trial. So now we go back to Essex County after the Supreme Court has decided.
At the trial level.
Have another trial. This time we win again. Mom was appointed counsel. And I say this because this is not the first and it won't be the last. Mom doesn't even bother to show up for trial. So she's had counsel appointed. She has been given her new day in court 4 years after the initial one.
Which is good. I want our audience to know this was not a bulldoze situation. Biological mom was given every chance.
Correct. And an attorney was appointed for the child this time. It was basically treated the same way a DCPP case would have been treated. I mean, everyone had an attorney and all the attorneys were free, except my clients paid me. Much to their chagrin, they would have liked to also have a free attorney. But we have this trial, and in 2017, we win, right? Air quotes, we win. Well, what does that mean in this case? That means an adoption was allowed to happen. The rights were terminated, except even though mom didn't come to the trial and participate, on the 45th day, which is the last day that you could appeal, she files an appeal of the termination. Right. We had assumed, because we didn't see her, she didn't come to the trial, no one had heard anything from her. We just assumed she had disappeared and was going to let this happen. And she literally waited till like 4 p.m. on the last day she could file an appeal to file an appeal. And months later, now I think we're in 2018, case goes back to the appellate division. And ironically, and by the way, this typically does not happen. We end up getting the same appellate division judges, 2 of them, from the first decision where we lost. And this time when I showed up for oral argument, I saw the judge saw me, and we look at each other. And I think the first words out of my mouth was, "This is now a different case." And she was nodding her head up and down. And I sort of had a sense of relief come over my body.
A different case because of what had transpired in the previous several years.
And my clients were sitting there in the audience, and I kind of looked at them and sort of, they had a sigh of relief, because although we lost with this appeals judge the first time, she sort of cut me off and she said, "Yes, Mr. Nunn, the procedure was handled completely different this time around." I didn't even have to argue for very long. It was the easiest oral argument I've ever had. Ultimately, I think it was probably 2 months after the argument, now the appellate division says, okay, the adoption can go through. The court can now enter a judgment of adoption, except now we had to wait to see if she went back to the Supreme Court again.
Another 45 days.
In this instance, it's a maximum of 30, but she didn't do it. But the court system being what it is, unfortunately, sometimes, ultimately, the judgment of adoption doesn't go through until 2019.
Wow.
So 7 years after this starts, my client were finally able to adopt their daughter.
I remember when you were going through that and representing this family, how intensely involved and committed you were. What does that family, what does that story mean to you as a lawyer? You know, one of the things we set out to do when we started this podcast was to make approaching or talking to a lawyer a little less intimidating. And the human aspect is so important. What does that family mean to you? What does that story mean to your heart?
When you attend law school and you have these romantic visions of what it's like to be a lawyer, you're gonna be rich, but you're gonna change the world. You're gonna do all these great things, and then you get into practice.
Yep.
Right, and that doesn't necessarily happen every day. You know, this was a case where if this little girl had stayed with her biological mother, having lived with the case, I can say this without any equivocation: her life would have been awful. It would have been awful. So we quite literally changed her life. Now, clearly, the most important people in this are the adoptive parents. They wanted to change her life, and they did, but we as attorneys facilitated it. And again, I remember sitting in court when the adoption goes through, sobbing that after 7 years, boom, you know, the judge enters the judgment of adoption, and it's over, and nothing else can happen.
How's the family doing now?
Oh, they're doing great. They still send me pictures on the holidays, you know, every year. So, and I hear from them. I hear from the adoptive mother frequently. I can't think of anything more important that I've done as an attorney. I've had some other noteworthy cases that involve custody, which I feel very similar about. But yeah, this is definitely one of them. And again, it highlights, Pat, something we said. It is very difficult to intrude upon or terminate the parental rights of a biological parent, but it's possible.
And at the end of the day, a child or children have such a bright future. So, Matt, I know we have so many more stories like this that we'll have to talk about on another episode. I'm always intrigued with the work you do, the out of box thinking that you have that create families, that create a new definition of family. So we could get away from the concept that a traditional family is this limited unit. We live in a world now where community is sometimes family, same sex couples are family, aunts and uncles are family. I have a family that we're just we are a village. We've raised our children like that. So it's so refreshing to hear a lawyer who takes that commitment and does something about it. And I thank you for your work. And I thank you for being a guest on our show today. I look forward to many more conversations.
Thank you so much for joining us today. Don't forget to follow us on your favorite podcast platform. Please give us a 5-star rating and leave a review so more people can listen in to Heartbreak and Hope with Pat Barbarito.